A very warm good morning to you all. I'm Grisma Pokhrel and I'm going to deliver my presentation on meaning and nature of company. I'd like to start my presentation with meaning of the word company. Simply, a company means companionship or the condition of being with another or others, especially in a way that provides for friendship and enjoyment. So, what is company? We all know in a simple sense, company means companionship or a friendship. It is a fellowship to achieve some common goals, to achieve some common objectives. We all have companies with whom we aspire to achieve some goals. You and me, we have companies to with whom we aspire to achieve some goals, to achieve some common objectives. So company is in a simple sense means companionship or fellowship to achieve some goals. Literally, a company is an institution for association, so it implies an association of a number of people for some common desires and for some common goals. The word company is derived from the Latin word cum, which means with or together, and panis, which means bread. So, etymologically, company refers to an association of persons who took their meals together. This is the etymological meaning of the company. Company is a number of individuals assembled or associated together to achieve some common objectives. And in the legal context, company is a business entity which acts as an artificial legal person formed by a legal person or a group of legal persons to engage in or carry on a business or industrial enterprise. This sentence means it has its own independent corporate existence and it is a distinct legal person. It is different from its members or shareholders, which is independent entity. A company is a legal entity representing an association of people, whether natural, legal, or a mixture of both, with a common purpose and a unite to achieve specific declared goals. Actually, company is called a legal or artificial persons because it is number one, invisible, number two, it is intangible, and it exists only in the contemplation of the law. So, it is a legal entity, and also it is capable of enjoying rights and being subject to duties as well as obligations. That's why company is a legal entity or artificial legal person. A company is a body corporate or an incorporated business organization registered under the Companies Act. Incorporation means under the Companies Act, the company is vested with the corporate personality, which is distinct from the members who compose the company, which is distinct from the shareholders, which is distinct from the partners of the company. So, company is corporate personality. Uh, it can be limited or an unlimited company, private or public company, company limited by guarantee, or a company having a share capital, or a community interest company. So, there are different types of companies. They may be limited, unlimited, private, public, community interest, even one-person company, registered companies, statutory companies, and many much more. A company is an association of both natural and artificial persons and is incorporated under the existing law of the company. Company related business has much more benefits than other forms of business like partnership, sole proprietorship, etc. Actually, company related business has more advantages and benefits because they include different features like limited liability, perpetual succession, transferability of the shares, separate property, etc. Therefore, a company is a corporate body and a legal person having status and personality distinct and separate from the members constituting it. But uh, generally, company is also similar to natural persons in many respects. For example, like a human being, a corporation, being as a corporation, human being have parents, which is similar to promoters for company. Likewise, birth, death, right and duties, marriage of human, and MOA, AOA, amalgamation, winding up for the companies respectively. So, in some respects, natural person is also similar to the company. Let's see some definitions of company. Nepalese Companies Act 2006 Section 2A defines company as any company incorporated by Companies Act. So this is the definition given by Nepalese Companies Act 2006, while Section 3 of the same act mentions the provision of incorporation of the company. Also, the Companies Act 2013 of India defines company as a registered association, which is an artificial legal person having an independent legal entity with a perpetual succession, a common seal for its signatures, a common capital comprised of transferable shares, and carrying limited liability. Also, English Limited Liability Act 1856 defines company as legal person or legal entity separate from and capable of surviving beyond the lives of its members, capable of rights and duties of its own, endowed with the potential of the perpetual succession. Perpetual succession, we can also call perpetual succession as perpetual existence of the company. Lawrence Gower views that the word company has no strict legal meaning, and according to him, a company implies an association of a number of people for some common object or objects. And in common law, a company is a means of cooperation and organization in the conduct of an enterprise. So from all the above mentioned definitions, what we can note is, what we can take into account is, firstly, company is a legal person, and a legal person is recognized by law having legal rights and is subject to obligation. That is the first point. And secondly, a company is a person or a group of persons, and actually nowadays it is no more required to be an association of persons to form a company. A company can also be started as a single person company, which we can call one person company. So, however, company is a person or a group of persons. Moving to the next slide, we have corporate personality and nature of the company. In fact, corporate personality itself is the basic nature of a company. Corporate personality is an artificial juridical person created by law, clothed with many rights, obligations, and duties prescribed by law. A company is a corporate personality. A corporate body is the creation of law. So, company possesses only the powers conferred by its MOA, AOA, and the provisions of Companies Act. MOA means a Memorandum of Association, that is a charter of company. MOA, that means a Memorandum of Association, is a legal document prepared during the formation and registration process of the company to define its relationship with shareholders. And AOA means Articles of Association. AOA, what AOA do is it safeguards and structures the business and also helps in establishing the company's identity, methodology, and the goal. So the powers of company are confirmed by MOA, AOA, and the other provisions of Companies Act. Companies Act. So, within the limits of powers conferred by MOA and AOA, a company can perform all its acts. Now, let's discuss about corporate personality. Corporate personality is the fact stated by the law that a company is recognized as a legal entity distinct from its members. Actually, a company incorporated under the Companies Act is vested with a corporate personality, so it bears its own name, acts under that name. Its assets are separate and distinct from its shareholder, distinct from its members, and distinct from partners. So, corporate personality is the fact stated by law. Next is, a company with such personality is an independent legal existence separate from its shareholders, directors, officers, and creators. A company with a corporate personality has the principle of separate personality. So the principle of separate personality of a corporate body means a company as a separate person incurs the company's debts and members do not incur its debts. So it is a different person from shareholder or members who compose the company. Next is, a corporate personality is capable of owning property, incurring debts, borrowing money, having a bank account, employing people, entering into contracts, and suing or being sued in the same manner as an individual. So what we can take from this point is, a company is separate entity in law and is capable of owning property, concluding contracts, and also sometimes committing torts and crimes. Also, incorporation is the act of forming a legal corporation as a juristic person, conferred with rights and obligations, and is dealt according to law. This means a shareholder cannot be held liable for the acts of company, even if the shareholder owns the entire share capital, because shareholders are not the agents of company. They cannot bind the company by their acts. So, shareholder cannot be held liable for the acts of company. So, being the most basic nature of company, a corporate personality is an independent legal existence distinct from its shareholders, or distinct from the members of the company, or distinct from the partners of the company. Now let's move towards some other nature of a company rather than corporate personality, because corporate personality is itself the basic nature of company, and some other nature are separate legal entity. A company is perceived to be distinct legal entity. Once incorporated under the act, the company is vested with the corporate personality, which does not depend on its members. It means the company bears its own name, acts under its own name, and its assets are separate from its members. The money credited by the creditors of the company can be recovered only from the company and its properties. It is capable of owning property, number one. Number two, incurring debts, also borrowing money, having a bank account, employing people, entering into contracts, suing or being sued. So the company is not liable for individual debts of the members. We have the cases which can describe this very nature of the company very clearly. First, we have Salomon versus Salomon and Company Limited case. In this case, Mr. Salomon had carried on prosperous business as a leather merchant or boot manufacturer. He formed a limited company consisting himself, his wife, daughter, and 4 sons as shareholders. But unfortunately, the company ran into difficulties. That is, there was a liquidation, we can say. The unsecured and other unsecured creditors claimed a priority over the debenture holder on the ground that company and the Salomon were same person. They were not different person. The other unsecured creditors claimed that. But the House of Lords in this case recognized that a company's business is conducted by company as a separate person. So the principle of separate legal entity was explained and emphasized in this case. It established beyond the doubt that in law a registered company is an entity distinct from its members, even if the person owns all the shares in the company. We have another case, Lee versus Lee's Air Farming Limited case. In this case, a company was formed for aerial top dressing, and Lee was the qualified pilot who held all the shares in the company except one share. And he voted himself the managing director and also got himself appointed as chief pilot. But unfortunately, he was killed in an air crash while working for the company, and his widow wife claimed compensation for the death of her husband, but the insurance company opposed the claim on the ground that Lee was not a worker of this worker, as the same person cannot be also the employee and also the employer. The insurance company claimed that, but under that
because there was the Lee was the director of the company. They was working as
also,
director
yes,
and
director of the company, and also he got himself
working
appointed
as
as chief
pilot. Yes, the
chief
insurance
pilot,
company
and he
says
was
that
also the
he's not an
managing
employee.
director of the company. And the Privy Council of England held that Lee and his company were distinct legal persons entered into contractual relationship. What was the contractual relationship? According to that relationship, he became a chief pilot, that is, a servant of the company. So, according to that relationship, the relationship was between himself and the company as servant and master. So, they were not the same person. The Privy Council of England held that. So these were the cases related to separate legal entity, and the in Lee versus Lee's Air Farming Limited case, the compensation for the dead husband was held valid because the Privy Council of England held that they were distinct legal persons entered into contractual relationships. Now next is limited liability. Limited liability means the company's debts are its own and members are protected from personal liability unless they are negligent or given personal guarantees. Actually, unless the members of the company are negligent or they are given personal guarantees, the company's debts are its own and members are protected from that personal liability. The company, being the separate person, is the owner of its assets and bound by its liabilities. In a company limited by shares, the liability of members is limited to the unpaid value of the shares. In fact, a company may be of two types, or it can be limited by two ways. Limited by shares or limited by guarantee, which means in the case of limited by shares, if the shares are fully paid already, then the members need not contribute any more towards the company's debt. That was the case of company limited by shares. And in the case of company limited by guarantees, the liability of members is limited to a specified amount of guarantee mentioned in MOA, that is Memorandum of Association. So that was the case, that is the case of company limited by guarantee. Also, the Companies Act 2006 of Nepal holds that the liability of shareholders of a company incorporated under the Company Act in respect of its transactions shall be limited only to the maximum values of shares which has been subscribed. And Companies Act of Nepal also provides that what we need to understand is this is the important point. Companies Act of Nepal also has provided that a private company shall add the words co-limited, that is company limited, to its name, and public companies shall add the word limited to its name as the last words. Companies Act of Nepal has provided this provision. Next is perpetual existence. It means that the membership of a company may keep changing from time to time, but shall not affect its continuity. Its life does not depend upon the death, insolvency, or retirement of any or all shareholders or directors. Law creates it and law alone can dissolve it. This means what we can understand from this is an incorporate company never dies except when it is winded up as per the law. This means only the law can wind up the company. A company is unaffected by death or departure of any shareholders, and it remains the same despite all the total change in membership. Therefore, perpetual existence, which can also be called as perpetual succession, means that the membership of company may keep changing from time to time, but that shall not affect its continuity. Professor Gower mentions members may come and go, but the company can go on forever. During war, all the members of private company were killed by a bomb. Survived, so not even a hydrogen bomb could have destroyed it. This was said by Professor Lawrence Gower. This means what he meant was the death of the member leaves the company unmoved. Members may come and go, but the company can go on forever. This was all about perpetual existence. Now next is separate property. A company, being a legal person entirely distinct from its members, is capable of owning, enjoying, and disposing of property in its own name. So, company is the juristic person in which all its property is vested and by which it is managed, controlled, and disposed. Although its capital and assets are contributed by its shareholders, they are not private and joint owners of its property. So, this very nature of company was defined in the case Purushottam Acharya versus Boris Barr et al. 2044. In this case, the Supreme Court recognized that company can hold property of its own because the nature, separate property, is the important nature of the company. Now, next is capacity to sue and be sued. A company, being a corporate body, can sue and be sued in its own name. All legal proceedings against the company are to be instituted in its name. Also, the company may bring an action against anyone in its own name. To sue means to institute legal proceedings against a person, or also to bring suit in the court of law. And all the legal proceedings against the company are to be instituted in its own name. The legal rights of the company belong to the company as a separate and not to its shareholders. A company's right to sue arises when some loss is caused to the company. Whenever some loss is caused to the property, or we can say personality of the company, a company can sue in its own name. Hence, the company is entitled to sue for damages. In the case Floating Services Limited versus MB San Francisco de Paola 2004, it was established that a company as a person distinct from its members may even sue one of its own members. This is the right given to the company, which is recognized as the capacity to sue and be sued. They can even sue its own members. So that is the nature of the company. Next is transferability of shares. This is another important nature of company. The capital of the company is divided into parts, which we call shares. The shares are said to be movable property and subject to certain conditions, freely transferable so that no shareholder is permanently or necessarily bounded to the company. The right to transfer shares is a statutory right. So, since this right is statutory rights, it cannot be taken away merely by provisions in articles. This is statutory right, so it cannot be taken away, and transferability of the share is the important feature, or we can say important nature of any company, any artificial legal person or corporate personality. Now next is we have common seal. Common seal means the common signature. We can say a company has no physical existence, so it must act through its agents, and all contracts entered into it by its agents must be under the seal of the company. So a company cannot sign documents by itself. It acts through natural persons who are called directors. To be legally binding on the company, a document must carry the company seal on it, and that common seal is used with the name of the company engraved on it as the substitute of its signature. So common seal is also the important nature of the company. Next, we have contractual rights. A company being a legal entity distinct from its shareholders can enter into contracts for the conduct of business in its own name. A shareholder cannot enforce a contract made by his company. He is neither a party to the contract nor entitled to the benefit derived from it. This means a company is not a trustee for its shareholders, and a shareholder of a company cannot sue in respect of torts committed against the company, nor the shareholders can be sued for torts committed by the company. It's like vice versa. A company cannot sue the member for the torts committed by it, and also the members cannot sue the company for the torts committed. Also, a shareholder cannot be sued on the contracts made by his company. So contractual rights is also the basic characteristic or the nature of the company. Next is voluntary association of profit. A company is undoubtedly a voluntary association of profit. It is formed, or it is any company is established for the purpose of profit. We all know that it is formed to accomplish some goals, and whatsoever profit is gained, it is divided among its shareholders or saved for the future expansion of the company. So whatever profit is earned from the accomplishment of goals of the company, shareholders, associates to equally consume that profit. Also, sometimes that profit earned is saved for the future benefit of the company itself. So voluntary association for profit is also the important nature of the company. Next is separate management. Company has a separate management. The member of the company can derive profits without being burdened with the management of the company. They do not have effective and intimate control over its working. The company is administered and managed by managerial personnel. We can understand this like in a way the members of the company themselves elect their representatives as directors on the boards and directors of the company to conduct corporate functions through managerial personnel. So and they are employed by themselves. So there is separate management in the company through which the members of the company can derive profits without being burdened. Now, last but not the least, termination of existence. A company is created by law, carries on its affairs according to law, and ultimately is affected by law. In fact, a company is an artificial juridical person, so it does not die natural death. It works according to law throughout its life and ultimately is terminated by law itself. Not any other force can terminate the company except law. Generally, the existence of company is terminated by means of winding up. Winding up means the process of dissolving a company while it ceases to do usual business. Winding up simply means the process of termination of the company by dissolving the company, in which the company ceases to do usual functions, usual activities. So through winding up, a law can terminate a company. But to avoid the termination or to avoid the winding up, some companies sometimes adopt strategies like reorganization, reconstruction, and amalgamation. Reorganization means a process where a company overhaul of its current strategy. Overhaul means overtake or pass. Overhaul its current strategy, setup, and operation. And reconstruction means transfer of company business to new company, and um, amalgamation means combining two or more companies into a new entity. So through these processes, some companies try to avoid winding up, that is the termination of the company. But termination of the company or winding up of the company allows the company to sell off the stock, pay off the creditors, and distribute remaining assets to the partners and shareholders, and finally cease to exist, that is finally terminated. So a company is terminated through winding up. Hence, a company is a separate entity in law which has access to limited liability, separation of ownership from the control, perpetual succession, transferability of shares, and raising finance. So concluding my presentation, I'd like to summarize the concept of the company as the association of number of people to achieve common objectives with different advantages such as limited liability, separate property, perpetual existence, transferability of the share, etc. And also is capable of enjoying rights and duties and being subject to the obligations. So thank you so much everyone for listening to me with so much of patience, and I'd like to be happy to receive feedbacks or any queries if you have. Thank you, sir. Thank you, everyone.
Okay. Thank you, Grishma, for your nice presentation. Yes, this is all FFC, general conceptual framework and general characteristics and features of a corporate personality. Yes, we know that people are registered to the company by to carry out this certain business with the certain objectives. Yes, they have registered the company because it is group of a person. Company refers to it's a group of a people who register the company. Those the people who have a common interest. The common interest people may stay together and they come together and they run the business that we call as a company. So company is legal personality gains after its registration, and its legal personality is terminated and dissolved only after the dissolution of the company by applying certain legal formalities. There is a corporate personality. So there is different features of corporate personality in that as a corporate personality has a separate legal entity, limited liability, perpetual succession, separate propriety, can sue and be sued, certain legal formalities, common seal, and there is financial, it is governed by MOE, AOE, and the financial clauses are there. These are the basic features of a corporate personality. So with these, corporate personalities are generally endued with these formalities. And the corporate personality has been developed by the description and by interpretation of the law and interpretation of the law by the court as well. Especially the origin and development of the company comes from with the history of the Britain, and there is different cases. It has been decided that in the different cases, for example, Solomon versus Solomon, in the case of the Lee versus Lee agro farming, and these are the different cases where the concept of corporate personality was developed and interpreted. And with this interpretation of the law by the code, the concept of corporate personality and company has been developed. And now there is one a kind of the own question has been as extremely raised, that is that the concept is that now there is the concept of the AI has been developing now. AI refers to, it means artificial intelligence, whether the artificial intelligence has the legal personality or not. Now this is the debatable issues over now time. So with the change of the society, with the changed context of the time in the society, the new concept has been developing. So that now whether the company is a legal person, yes, but it can't It can't, it can't speak in its own name. It can't speak itself. It can't speak. Company itself can't speak because it is ultimately run by the human being. So that's why company is endorsed with the legal personality. And whether the AI refers to intellectual artificial intelligence, it is also created by the human being. So whether artificial intelligence has the legal personality or not, this is also questionable, debatable question. Now it is raising. So that's why yes, I concept of the corporate personality. Yes, it is endued with the corporate personality. With these certain features, it is considered as a legal person. So company is a legal person, and it can sue and be sued in its own name, and it can be considered as endowed with the different features. We can say that yes, as human being, they could own their property in its own name. As a human being, they could sue sue or file the case in the call. This is the basic features of the corporate personality we could see. So the concept and basic features of the corporate personality or the company or nature of the company, we can deal in this way. Okay. Yes, thank you, Grishma, for your nice presentation. And any question of you about the presentation? Any comments about the presentation? If there is any question, you could talk. Okay. Otherwise for today, yes, thank you for the nice presentation again, Grishma. And tomorrow we'll listen to the
Thank you, sir.
Indica. Yes, Indica Basnet. To the Indica Basnet, we'll listen on the topic of origin and development of the company. UK, India, and Nepal. We'll listen tomorrow to her. Okay.